If the original meaning was to discourage people from partaking in party NBS, and the new song's meaning seemed to be celebrating party NBS, isn't that new meaning? Isn't that transformation?
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
All right. So I know you were all waiting with bated breath for the outcome of the Oyewole versus Aura appeal. I know it's been such a long time that you guys have been waiting since 2018. No, this is the Biggie Smalls case. This is an appeal from the Southern District of New York. It is hereby ordered, adjudged, and decreed that the judgment of the district court is affirmed. So that means if you already know what the judgment was of this, in this case, the district court that we're going to go over in a moment, then that's been affirmed. Abiodun Oyewole, I have no idea if I'm pronouncing that right, appeals from the March 8th, 2018 judgment of the U.S. District Court for the Southern District of New York, dismissing Oyewole's copyright infringement lawsuit pursuant to Federal Rule of Civil Procedure 12b-5 as to some defendants and 12b-6 as to other defendants. We're going to refresh our memory what 12b-5 is. FRCP 12b-5 is insufficient service of process. Okay, so that means they weren't served. We assume the parties' familiarity with the facts, record of prior proceedings and arguments on appeal, which we reference only as necessary to explain our decision, and we're going to read through this decision first and then go back to the fair use section of the other decision and see if there's anything else to gather from that. The following facts are drawn from the allegations in the complaint, which we assume to be true. Oyewole is a founding member of The Last Poets, a spoken word rap group that created and published When the Revolution Comes in 1968, with lyrics that paint a picture of violent revolution and African American empowerment. When the Revolution Comes ends on a cynical note, quote, "When the revolution comes, Afros gon' be trying to straighten their heads, and straighten heads gonna be trying to wear afros. When the revolution comes, when the revolution comes, when the revolution comes. But until then, you know and I know N-words will party and BS and party and BS and party and BS and party and BS and party. Some might even die before the revolution comes." In 1993, Christopher Wallace, better known as the notorious B.I.G. or Biggie Smalls, created a song called Party NBS by sampling When the Revolution Comes and remixing the Party NBS phrase. After B.I.G. died, his estate licensed the use of the phrase Party NBS to Rita Ora and her hit single How We Do Party, which was released in 2012. Oyewole sued B.I.G.'s estate, Rita Ora, and various songwriters and producers involved in the creation of Party NBS and How We Do Party for copyright infringement, alleging that he never authorized the defendants to use the phrase Party NBS and never received any royalties from their infringing works. The district court, assuming, arguendo, that Oyewole had an ownership interest in When the Revolution Comes, that the phrase Party NBS was a protectable expression, and that the works at issue were substantially similar, dismissed the complaint on the ground that the fair use doctrine applied as an affirmative defense. The fair use doctrine requires a court to consider 4 non-exclusive factors. Remember, this is a balancing test. 1, the purpose and character of the use. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. 4, the effect of the use upon the potential market for or value of the copyrighted work. And remember that 4th factor is called the market usurpation factor. The district court concluded in a thorough and well-reasoned opinion that on balance, these factors support a finding that the secondary works constitute fair use. On appeal, Oyewole principally argues that the district court erred in determining that the songs constitute fair use of the Party NBS lyrics. Specifically, Oyewole contends that the 4 factors weigh in his favor because 1, the allegedly infringing songs are commercial and by virtue virtue of a lack of aesthetic change to the original lyric insufficiently transformative. 2, the fact that when the revolution comes is expressive outweighs the countervailing fact that it is published. 3, the party and BS lyric is a substantial portion of when the revolution comes from a qualitative perspective. And 4, Oyewale's status in the hip-hop community renders the allegedly infringing songs likely to usurp the market for when the revolution comes. We review de novo a grant of a motion to dismiss pursuant to 12b-6, accepting the complaint's factual allegations as true and drawing all reasonable inferences in the plaintiff's favor. Is that part drilled into your head yet, you regular viewers? Upon review, we conclude that the district court properly granted the defendant's Rule 12b-6 motion to dismiss because the allegedly infringing songs constitute fair use. Great. You've been here doing this story with us for the last 10 minutes, and that's what the court gives you. That's the entire fair use analysis. We therefore adopt the district court's fair use analysis in all respect, and on that basis affirm the dismissal. So yeah, that's the district court just saying, oh yeah, we like what they said, and then signing their name to it. That's how they do that. So having done so, we need not reach the service of process issue. We have considered Oyewale's remaining arguments on fair use and conclude also for the reasons ably stated by the district court that they are without merit. Accordingly, the judgment of the district court is affirmed. Okay, so then let's switch over to this other case, the district court case, where Allison Nathan, we've read Judge Allison Nathan's opinions before, right? So here's the background. And let's see if there's anything in here that we can really garner from it, because we don't really want to read every word of this again, if we can. Because there it is. There's everything that we just saw. And then here begins, here we go. Party NBS song begins with Wallace rapping, "I was a terror since the public school era. Bathroom passes, cutting classes, squeezing asses. Smoking blunts was a daily routine since 13, a chubby N-word on the scene." The song continues, "Honeys want to chat, but we all want to know is where the party at? And can I bring my gat?" Before eventually leading into the chorus, dumbing out just me and my crew, cause all we want to do is party NBS and etc. The chorus repeats the phrase party NBS 9 times. Rita Ora released the 2012 pop song How Do We Party, which begins and party NBS, party NBS, and party NBS, and party and party. The song begins with Ora waking up and asking what went on last night. She then sings to her partner, "You look so sweet while you're dreaming, yeah, hold your bottle of Tanqueray. It isn't even the weekend, baby, that's how I know you're the one for me." There's more lyrics, and then she repeats the lines, "I want to party NBS, and party NBS, and party NBS, and party," several times throughout the song. According to Oyewale, the use of the phrase party NBS was intended to contravene or recall the original purpose of the phrase as used in his song When the Revolution Comes, which was to discourage people from partaking in party NBS. So, a different meaning then, isn't it? If the original meaning was to discourage people from partaking in party NBS, and the new song's meanings seem to be celebrating party NBS, isn't that new meaning? Isn't that transformation? Oyewale filed suit March 14th, 2016, and we're going to skip ahead to the fair use analysis. When deciding a motion to dismiss for failure to state a claim under 12b-6, the court accepts all well-pleaded facts and draws all reasonable inferences in light most favorable to the moving party. To establish a prima facie case of copyright infringement, a plaintiff must demonstrate ownership of a valid copyright and copying of constituent elements of the work that are original. To satisfy the second element, plaintiff must show the defendant has actually copied the work, and the copying was illegal because a substantial similarity exists between the defendant's work and the protectable elements of plaintiffs. Defendants make several arguments why Oyewale's complaint should be dismissed for failure to state a claim. The Rita Ora defendants primarily contend that no substantial similarity exists between party and When the Revolution Comes. 2, that the phrase party and bullshit does not, I said it, I know we can say that on YouTube, it's just repeated so often, I'm trying not to get myself demonetized. The phrase party NBS does not constitute a protectable expression. And 3, the use of party NBS in party constitutes fair use. Similarly, the notorious BIG defendants assert that plaintiff lacks valid ownership in an interest of a musical composition or sound recording in When the Revolution Comes, that's a standard one to attack whether someone owns the copyright that they say they do. 2, party NBS is not protectable expression. Party NBS and When the Revolution Comes are not substantially similar. The use of the phrase is fair use, or the statute of limitations bars or partially bars the claim. The court assumes arguendo that Oyewale has a sufficient ownership interest. Federal law provides that fair use of a copyrighted work for purposes such as criticism, commentary, news reporting, teaching, including multiple copies for classroom use, scholarship or research is not an infringement of copyright. They list the 4 use factors. The ultimate test of a fair use is whether the copyright law's goal of promoting the progress of science and useful arts would be better served by allowing the use than by preventing it. They quote that from Cariou v. Prince. The fair use doctrine is intended to protect secondary works that add value to the original, that use the original work as raw material, transformed in creation of new information, new aesthetics, new insights, and new understandings, to boldly discover new copyrights where none have gone before. The fair use doctrine is an affirmative defense, and accordingly, the party asserting it bears the burden of proving it. So then we're going to actually get to the fair use factors now. On the purpose and character of the use, courts consider whether the allegedly infringing work supersedes the objects of the original creation or instead adds something new. This factor is the heart of the fair use inquiry. Indeed, the goal of copyright, to promote science and art, is generally furthered by the creation of transformative works. In analyzing the transformative nature of the works at issue, courts examine how the works may reasonably be perceived. A secondary work may constitute a fair use even if it serves some purpose other than those criticism, commentary, news reporting, teaching, scholarship, or research identified in the preamble to the statute. There is no requirement that a work comment on the original or its author in order to be considered transformative. Okay, so there's an argument in favor of Brandon and I have this kind of ongoing argument as to whether the fair use needs to be on a photograph or the subject of the photograph. So if there's no requirement that a work comment on the original or its author in order to be considered transformative, then yes, you could put somebody's photograph directly into your work as long as it's transformative. I still argue that those other uses were not necessarily transformative. They were using the prison's photo to refer to the prison in the Good Mythical Morning example. Instead, the critical inquiry is whether the new work uses the copyrighted material itself for a purpose or imbues it with a character different from that for which it was created. So these are actually really important sentences here. And that's from TCA Television Corp v. McCullum. Thus, secondary works are transformative when the original works are serene and deliberately composed, black and white photographs, while the secondary works are collages that incorporate color, feature distorted human and other forms and settings, and are much larger than the originals because the secondary works manifest an entirely different aesthetic than the original. That's from Cariou. Remember, Cariou v. Prince was one of the collage cases. On the other hand, the Second Circuit has held that a play's use of the copyrighted Who's on First routine was not transformative when the defendant had argued that the allegedly infringing work transformed the purpose of the routine from comedic to dramatic, but the routine was unnecessary to serve the claimed dramatic purpose, advancing the plot of the play. The court further explained that although the play itself conveyed a dark critique of society, the play did not transform the routine so that it conveyed the message. As part of the first factor, courts also consider whether the allegedly infringing work has a commercial or nonprofit education purpose. A commercial purpose pushes towards a conclusion that the work did not use the original work fairly, but Congress could not have intended a rule that commercial uses are presumptively unfair. Here, both party NBS and party transform the purposes of the phrase party NBS from one of condemnation to one of glorification. So that's defendants' works. Unlike the routine in TCA Television Corp, The phrase party NBS itself is transformed, and neither secondary work does it evince criticism or foreboding. When the Revolution Comes, the original, is a political song that warns of an approaching violent revolution. The last poets want their listeners to prepare for the revolution, appreciate its gravity, commit themselves to it. They explain that only things of substance will survive the revolution. See the lyrics, when the revolution comes, transit cops will be crushed by the trains after losing their guns, and blood will run through the streets of Harlem, drowning anything without substance. The cost of revolution is 360 degrees. Understand the cycle that never ends. Speak not of revolution until you are willing to eat rats to survive. At the end of the song, the poets criticize those who will party NBS until the revolution comes, and they suggest that as a result of the party NBS, some might even die before the revolution comes. In When the Revolution Comes, therefore, the phrase party NBS is part of an admonishment, an expression of disgust and disappointment in those who are not readying themselves for the revolution. By contrast, party NBS embraces the party NBS culture. This is the modern one, thereby transforming party NBS, the phrase, from something shunned to something glorified. In party NBS, then, the lyric is a desired activity, part of Wallace's hip-hop lifestyle, which the song celebrates. Likewise, party exalts the party NBS lyric rather than condemning it. Aura sings with joy about it. She explains that her partner is the one for her because she is holding the bottle and it isn't even the weekend, and she sings about shutting down every bar and tearing up the town. She cheerfully proclaims she wants to party and BS. Unlike When the Revolution Comes, party does not denounce the lyric, but instead suggests that it is fun, lighthearted, and enjoyable. Moreover, in addition to the songs themselves, the complaint supports the conclusion that party NBS and party are transformative. Indeed, Oyewale acknowledges that the Big and Rita Ora defendants use the phrase in contravention of the original purpose, which was to encourage people not to waste time with party and BS. Thus, even Oyewale recognizes that defendants' songs change the meaning and purpose of the phrase. A comparison of the works at issue, along with Oyewale's own statement regarding the phrase, reveal that the defendants' works transform when the revolution comes, imbuing it with a character different from that for which it was created. Although the defendants' songs clearly have commercial purposes, that alone does not suggest that Big and Ora unfairly used the work, the original work. Accordingly, the first factor strongly supports a conclusion that party NBS and party are protected by fair use. So we're going to skip the second factor because they pretty much just did that for us. In analyzing the third factor about how much was copied, party NBS and party each use one phrase from When the Revolution Comes. The last poets repeat the expression approximately 4 times at the end of their song. They do not use it anywhere else. Moreover, although the background tracks cutting out when the last poets chant party NBS adds a level of gravity and importance to the phrase, the expression is not critically important to the song's message. Instead, the song focuses on the upcoming revolution, describing what will happen and repeating when the revolution comes. The criticism of those who party NBS reinforces the last poet's message that their listeners should prepare for and commit to the revolution, but it is not essential to that message. Let's see if we can find the song and listen to the end of it here.
And party and bullshit and party. Some might even die before the revolution comes.
So so that's the one. Let's go see if we can find how Biggie Smalls uses it here. Oh, so it's not even a sample. Do we have Rita Ora's one? It's just right off the bat. All right, might as well just use those first 5 seconds there. So that's what we're talking about. Those are the use of the party NBS lines that we're talking about. Can you believe that we're at like a multi-year copyright lawsuit over the use of just the phrase party and BS? Wow. On to the fourth factor. The concern animating the fourth factor is not, so we're going to learn what it's not, whether the secondary use suppresses or destroys the market for the original work, but whether the secondary use usurps the market for the original work. An accused infringer has usurped the market for copyrighted works, including the derivative market, where the infringer's target audience and the nature of the infringing content is the same as the original. Indeed, a fair use must not excessively damage the market for the original by providing the public with a substitute for the original work. So would those last two songs act as substitutes for the first song? Nah, not at all. The more transformative the secondary use, the less likelihood that the secondary use substitutes for the original. Defendants' songs are unlikely to usurp the market for When the Revolution Comes because, as explained, the allegedly infringing works are different in character and purpose from the original work, and it is unlikely that defendants' target audience and the Last Poet's audience are the same. Even if they are, defendants' works are significantly different from Oyewale's and thus do not provide the public with a substitute for When the Revolution Comes. On balance, the factors weigh in favor of the conclusion that Party NBS and Party are fair uses of When the Revolution Comes. Accordingly, the Notorious B.I.G. and Rita Ora defendants' motion to dismiss the copyright infringement claims are granted, and then we saw earlier that they were also affirmed by the appellate court. So there you go. That is a really good explanation of transformation with regards to using another artist's lyrics in this case. So they used the Party NBS lyric from even, for example, just assuming that there is actual ownership in such a simple phrase, assuming all of that, we can get to the answer in fair use and say that the original work had a certain character to it, and the uses changed that character into something new. And you saw how well that was explained. This is a quintessential fair use. I'm going to declare it right now. Another H3H3 style quintessential fair use. They used the original to comment on the original. That's exactly what it's supposed to be. And in the process, made entertainment and content for us to enjoy. And once again, just let me say how what a great. I mean, I'm not like a fan or anything, but every time I listen to Biggie Smalls, he's just a great artist. He wow, that was great. I'm not a huge fan of spoken word or rap, as in, I mean, nothing wrong with it. It's just not like what I drive down the street listening to. I mean, for me, it's Christian rock all the way. And no, I'm kidding. So what do we think of that? Let us know your thoughts in the comments below. Thank you for joining me this morning. I am Leonard French, your favorite copyright attorney. Thank you for supporting us on patreon.com/ljfrench and sponsus.com/law. Your support is what makes this channel possible. We have taken Brandon full-time as a contractor in the month of October and continuing for the indefinite future here. And we could really use your support to make sure that we can pay him an appropriate living wage. Thank you to our October channel sponsor. Thank you to Joshua Davis from TandaPay. And thank you to our $50 plus supporters, Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov. Wow, there are a lot of you. Really love to see that. Thank you so much for all your support. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will be on the crawl in front of me on the videos that drop. You're all in the description. See more in the description. We have merch. We have links to TandaPay articles and all of your names as well. So go see yourself there. Love you all. Thanks for joining. Don't forget to share. Don't forget to subscribe and click the bell. Don't forget to like the video, and I'll see you later. I'll leave you with some dog video here. Love you all. Bye.
Hehehehe